Right, good morning. Good morning, everyone, and welcome to our Women in Sectional Title webinar. Thank you so much to our current sponsors, ZFIN, CIA, BCM Track, Meeting Pal, Sectional Title Solutions, We Connect You, and PKF Octagon. We really appreciate all your help. I would also like to just say, Serena de Freitas, happy birthday to you. We wish you a fantastic day. 16 days of activism against gender-based violence starts tomorrow, the 25th of November, and runs to the 10th of December. Someone very close to me has recently faced this and lost somebody, a family member, in a horrific domestic violence case. And I'd like to appeal to all of you. It really ought to be impressed upon all of you ladies out there that if ever you're in trouble, if ever you feel the need to reach out, share your problems, even to have someone to listen to, really, we're here for you, all our committee members, myself. My email address is marina@bbmlaw.co.za. You can direct anything to me if you like. And going forward, we needed you to know that. So bear that in mind. Right, so today we're talking about a few questions that arose before we introduce Fausto de Palma. I know he's waiting there in the wings. I'd like to take you through a couple of questions which were asked in the webinar, which Corinne Blaze and myself put on regarding how you successfully lodge CSOS application. And we really felt the questions were amazing. They were really good. It made me rack my brain actually and ask around, but here you go. If you want the answers to these questions, we'll prepare them for you and you just send me an email and we'll make sure that you get them early next week. So the first one, if you were to pursue a developer, would it have to be in a civil court? Because what we said is that the CSOS doesn't hear matters against developers, if you'll remember. So yeah, the answer is definitely you would have to go into a civil court environment and pursue the developer. And again, the costs are really a tough situation because you're going to have to pay a lot of money in litigation. So you've got to have your facts straight. And sometimes, in my experience, unfortunately, it's almost not worthwhile. Secondly, I'm aware that, for example, an owner can submit a CSOS case against a managing agent. Can a managing agent likewise submit a case against an owner? All right, so the answer here, if you're going to CSOS, an owner against an owner can go to CSOS. An owner against the body corporate can go to CSOS, and the body corporate versus an owner, that dispute can go to CSOS. But in terms of the definition of dispute in the Community Scheme on But Service Act, the interpretation that we can glean from that is that the body corporate can take a managing agent to CSOS, and a managing agent can take a body corporate to CSOS. But a managing agent can't take an owner to CSOS, and an owner can't take the managing agent to CSOS. So it's a bit tricky, but yeah. In terms of what a dispute is and in terms of Section 39, that just isn't a possibility. All right, duet schemes are very difficult to manage when one owner blatantly refuses to contribute and follow the Sectional Titles Act. Any advice as to how best to address this? Well, look, this is practical advice, and I've dealt with many duets, particularly in the Pretoria area. We've got an office in Pretoria, and every second matter we get there is from a duet scheme. And my advice is actually to take the matter to CSOS and just follow a mediation process there and get the CSOS mediator to explain to the owner of the difficult owner to explain exactly what sectional title is all about. We found that works quite well. Take it to CSOS, that one. Can CSOS invalidate a homeowners association constitution or governance documentation? Well, not as a whole, but certainly what the CSOS can do is to invalidate provisions of a homeowners association constitution, provisions which are discriminatory, contrary to public policy, contrary to our constitution. You can take out a provision and even substitute a provision in your governance documentation. So definitely. CSOS adjudicators are obliged to apportion liability for costs Section 54(1)(b). Very few published CSOS orders include a costs award, which means vexatious and argumentative opportunistic complaints are not discouraged. How do we ensure that costs awards are issued, including those costs that the body corporate has to incur due to fees charged by managing agents as they assist trustees in defending such complaints? Okay, well, the first thing that we need to understand is that if there are attorneys involved in a CSOS matter, and sometimes there are, remember the adjudicator has the discretion to allow attorneys. We're generally not allowed, but in complicated cases or cases where both parties insist on having an attorney, you can have an attorney. The legal costs from there, they can and often do, adjudicators often do provide for cost orders so that you can recover attorneys' costs and then have those costs taxed. So that's the first thing. Secondly, the CSOS Act tells you that if it's a vexatious claim, from the beginning, that can be dismissed with costs. So you don't go to adjudication if the adjudicators feel that the case is vexatious or problematic or argumentative. Before it goes to adjudication, they would dismiss the matter with costs. But bear in mind, the top amount of cost that they can order is 5,000 Rand. They can't order a cost award more than 5,000 Rand. Yeah, and it's a hassle, and the managing agents have got to schlep to the ombud, etc. But it's like being taken to court. It's the same thing. You can't discourage people. Hopefully a well-run complex will manage that better. Then someone was advised that the POPI Act overrides the Sectional Titles Act. No, definitely not. The POPI Act has to be seen and read together with the Sectional Title Schemes Management Act. We've got a directive, which was actually now quite hot off the press. The final draft on the 10th of November was issued by the Community Scheme Ombud Service on POPI and the Sectional Title Schemes Act, Management Act. You can go on their website to have a look at it. But it works together in conjunction with it. And of course, the Constitution has an overriding or overarching role there as well. Last few questions, these are the last ones. If slaughtering is a constitutional right, which of course we can all agree with, why should the rules provide for this? As a request cannot be unreasonably denied, this would be contrary to a constitutional right. Yes, quite right, it is a constitutional right, but the bylaws and setting out exactly what has to happen should be in the rules. So the rules are there for clarity and for the operational enforcement of what we see in certain acts. So that Meat Safety Act would then set out all the conditions. Have they paid? Is it going to be separated from the rest of the complex, etc., etc. So I think that should be in the rules. What is the course of action with CSOS if a current managing agent is fired due to not complying with services set out in the Act in relation to financial statements? They want to appoint new managing agents, but they're refusing to give the body corporate documents to the trustees. Can the scheme approach the CSOS in this regard? The answer to that is a resonating yes. They can, and if it's urgent, often these matters are urgent, and I've seen this in action where CSOS does step in and assist a body corporate getting books of account and record from the old managing agent to go to the new managing agent. Time it takes CSOS to respond when a case is taken on. How can one expedite the dispute resolution process, excluding the listed aspects deemed as urgent by CSOS? Well, again, you know, the CSOS is a statutory body, and there's no ways that you can really expedite the matter. Everybody is viewed equally in terms of the law. And at the end of the day, you know, if you've got an adjudicator on board, you can obviously chat to the adjudicator and ask, you know, how long it's taking, but certain time periods and time limits that an adjudicator has to adjudicate. And I know in the directives earlier on this year, they were saying they were changing those time periods to be quicker. And I think there's really a lot of political will behind things to move things along. But honestly, there's no real way you can expedite anything. Also, the time it takes depends. One case takes 6 months. One case I've heard takes 2 months. You know, it depends who your adjudicator is. similar to a court process. SGM is very difficult for the large body corporate. Well, yes, it is, but of course you do have your everything in place to hold an SGM. You need to have your quorum in place, and I think these virtual meetings have become a lot easier, to be very honest. And I'd recommend virtual meetings for all managing agents. All my clients really enjoy the virtual meetings. It's easier to manage. Is there a library of cases available and accessible? When I sat on the board of the Community Scheme Ombud Service, there certainly were moves being made, and I know current moves are afoot to properly document. You do have cases and case law from the community scheme online, but not all of them. And I think there's going to be a really big costs a lot of money, big money to get these cases sorted out, but we should see them come through pretty soon. All right, let's go on to Community Scheme Ombud Service appeal. So you've had an award granted, you think it's ridiculous, you think it's ludicrous, you think the adjudicator might have been drinking, and the client comes to us and says, we're appealing it right away. So what does Section 57 of the CSOS Act say? An applicant, the association, or any affected person who is dissatisfied by an adjudicator's award may appeal to the High Court, but only on a question of law, not of fact. So remember, this gets now taken out of the Community Scheme Ombud Service purview, and we're taking it directly to the High Court. It's expensive and it's time consuming. So you could see 3-4 years of work in the High Court to actually have an appeal heard. The very interesting thing that we heard at the NAMA conference was that hopefully the CSOS is going to look at an internal process for appeals, which I think is going to be the best thing that CSOS will have ever done. Number 2, an appeal against an order must be lodged within 30 days after the date of delivery of the order of the adjudicator. A person who appeals against an order may also apply to the High Court to stay the operation of the order appealed against to secure the effectiveness of an appeal. That's quite important, because if you've got a payment to make, for example, you don't want to pay it until the appeal's been heard, then you can stop that. Examples of grounds of appeal: did the adjudicator have the jurisdiction to rule in terms of Section 39 of the CSOS Act? So that might be one. Did the adjudicator have the right to order that the owner should pay money to the body corporate for arrear levies? But not, for example, did the adjudicator have the right to order that the owner should pay 10 installments of 8,000 Rand each for arrear levies? So it's very specific. Did the adjudicator have the right to order that somebody was restrained from doing something within the scheme? That's a question of law. Did the adjudicator interpret clauses within the trustee's resolutions or conduct rules correctly? Now, grounds of review. You might have heard people say appeal and review. What is the difference? Well, let's just first start off by saying that you can go on review for an award. And you can review an adjudication award based on common law principles or under Section 6.2 of the Promotion of Administrative Justice Act, PAJA. So it's often cheaper than appeals, but the only way you can review an award are the following examples. Firstly, the adjudicator was biased or reasonably suspected of bias. So in this kind of case, for example, I had one case where the adjudicator was busy having tea and coffee with my opponent before, and then they had chat after the whole thing together without us. As we left, they were still busy talking, and we took that on review. The administrator took a decision which he was not authorized to take. So in other words, where he's exceeded his powers. The decision wasn't rationally connected to the purpose for which it was taken. Had a few of those. Decision is so unreasonable that no reasonable person could have exercised the power or performed the function. The decision took into account irrelevant considerations or excluded relevant considerations. The decision was taken in bad faith or arbitrarily. The order was unconstitutional or unlawful. So that is a way you can certainly go. Now, how do you go about appealing? Within 30 days after delivery of the adjudication order, and you know what, they're so strict, you won't be able to get condemnation. So no condemnation is entertained And the application for appeal will be dismissed if it's not within that 30-day period. And there's a case there, Gala versus Park Avenue. In Baxter versus Ocean View, it's a Cape Town decision, High Court decision. Condemnation was granted and there was no mention of Gala. It was reportable, but hasn't still been reported. And I think we can ask Fausto for a little bit more information on that. But we did say staying operation of an order when making an application to appeal. You can include in your application that you want to halt the operation of the adjudication order until such time as the appeal has been considered and ruled upon. For example, if the adjudication order orders that you have to pay the money that we mentioned, you can apply for you not to pay that amount. That is quite a crucial part of everything. Right, so now I'd like to introduce you to the Chief Legal Officer of Sectional Title Solutions, Fausto De Palma. I'm sure you know him. We met again properly at the NAMA in Durban. Hi, Fausto. Fausto, are you there?
Yes, thanks. Hi, Marina, and thanks very much for inviting me, and to all the organizers of Women in Sectional Title. Thanks. It's great to be here.
Thanks so much, Fausto. I think you're going to take us from here.
Yes. All right, guys. So in this presentation, we've learned about High Court appeals against CSOS adjudication orders. The different procedures which apply in different jurisdictions is also relevant, and I'm going to take you through a little bit of that now, some tricks and traps, as well as some interjudicial debates surrounding the nature of the appeal process. So in Gauteng, as you know, you must follow a strict appeal process in terms of what was laid down in Stenison versus Linton Park, and we'll get to that case later on as I go through a journey with you, an overview of these of this case law. So in Gauteng, a notice of appeal must be lodged within 30 days after receipt of the adjudication award. And if there is a cross appeal that must be lodged, then it must be lodged within 10 days of receipt of the notice of appeal. Please note that in Gauteng, as Marina mentioned, the Nkala case ruled that you will not get condonation in Gauteng. Condonation for the late filing of a notice of appeal in Gauteng is not possible. The courts have ruled here that they do not have inherent power to do so because the Act, the CSOS Act, does not expressly provide for it. And there is a contrasting decision in Cape Town. So not only is there a different process in Gauteng and the Western Cape, but in the Western Cape you may get condonation. And we'll get to the Ocean View versus Baxter case 8 days ago. It was ruled, it was handed down. So that's an interesting one. Sticking with Gauteng, understand that when you file your notice of appeal or your notice of cross appeal, you must state what part of the adjudication order you are appealing against on a question of law only. And Marina kindly took us through what a question of law is, and I'm going to go through some of these cases to distill for you what the difference is between a question of law and a question of fact. It's not always easy to determine those differences. And then in Gauteng, obviously, the parties must file the record and the heads of argument and comply with the practice note as per the practice manual in this jurisdiction. Remember now, in Gauteng, you have to file an appeal process. So that's on notice of appeal. And a review application that Marina mentioned must be done on notice of motion. So you would have two different paths to follow there. It would be quite costly if you were to appeal and review in Gauteng, because you can't review via the notice of appeal process. So you can already see the cumbersome nature within which you would need to appeal or review the process in Gauteng. In contrast, the Western Cape, and it's also being followed in KwaZulu-Natal, all you need to do is file a notice of motion within 30 days of receipt of the adjudication order, and that notice of motion will be supported by affidavits and supporting documents, and you can get condonation. But we're going to get to Ocean View versus Baxter. In the Western Cape, you could conceivably get condonation, although that case did not mention the Gauteng case. Both courts actually make compelling reasons for their differing views. So when we get to that in the journey on the overview of case law, I will take you through that. On the notice of motion, you have to serve it on the CSOS, the ombud, the adjudicator, and obviously the respondent, but you must also serve it on the registrar of that specific court if that registrar has already made that adjudication order an order of court. It was one of the requirements in the Shma-Yahu case. I hope I pronounced that word right, the name of the party, Shma-Yahu. It's a bit of a tongue twister. So the benefit in the Western Cape and KwaZulu-Natal, because the process of appealing is on notice of motion, if the disgruntled party or the unhappy party wants to review on judicial review under PAJA or under the common law judicial review grounds, then they can do so in the same application. So it's less costly, but unfortunately that's not possible in Gauteng. You can go to the next slide now. Thanks. So other than these differences between the processes required to be followed in the different jurisdictions and the prospects of success in getting condemnation if you are late in any of those jurisdictions, we also find that it's sometimes very difficult to distill questions of fact from questions of law in an appeal in terms of Section 57 of the CSOS Act. We are restricted to questions of law only, but oftentimes questions of law have to be considered in light of factual findings themselves. And those factual findings may or may not have been correct, or they may not even be a factual finding that could be rationally connected to the conclusion of law reached by that adjudicator. Hence why Marina has suggested potentially a review process would be appropriate in that case. So for this study and for the article to be published by us in a few days' time after this presentation, the case law summaries for all cases where CSOS appeals have been dealt with is required in order to understand what a question of law is and where parties have been successful or unsuccessful, whether it be for condemnation or whether it be on the merits of the case on the appeal. So let's begin the journey in overview. It starts with the avenues versus Shma-Yahu. I'm not going to mention the dates as I go through these this road trip, I call it. I'm just going to tell you what the key takeaways and points of law are in each of these cases. And obviously the slides give direction on what the dates are. But in chronological order, the Cape Town High Court, 2 judges presiding, in Shma-Yahu determined a dispute regarding illegal extensions. So there was, the illegal extensions resulted in no change in the levy, because as you know, if you do an extension properly, there would be a change either way in terms of what the appropriate levy would be in terms of the adjusted PQs. So the disgruntled party lodged a notice of appeal with the record. So in that case, actually a notice of appeal was submitted to challenge the adjudicator's powers, but the court said, well, we prefer a notice of motion with affidavits, and that's where the whole interjudicial debate started. The court stated we must cite CSOS, the adjudicator, and the registrar as mentioned, and the point of law in Shma-Yahu was that the person making the claim was no longer a member of the body corporate, and therefore they had no material interest in the scheme any longer, and therefore could not launch the dispute in CSOS. So the question of law was whether CSOS had jurisdiction and whether the adjudicator's order was within their powers. It was held that they did not have jurisdiction, and that even if they did have jurisdiction, because CSOS cannot order an adjustment to a previous owner's liability in respect of levy contributions, as that has to be determined by the registered PQ, and in this case, there were illegal alterations, so that ruling would be in conflict with the registered PQs, and it was struck down. So in Shma-Yahu, that's where it all started. But we then move on to Pietermaritzburg and Durdock Center. In this case, the appeal was filed out of time, more than 30 days, but condemnation was not opposed, so condemnation was granted. 2 judges presiding also then followed the Shma-Yahu case in Cape Town and said notice of motion supported by affidavits was preferred, but there was no opposition to the process of noting the appeal, so it was never an issue. The question of law there was, did the adjudicator order the body corporate to reimburse the owner for electricity paid but not delivered, when he had no power to do so in terms of the CSOS Act? And then another question of law which was determined in this case was the locus standi of the applicant, which was successfully challenged in the specific case. So you have a Durdock, and then after Durdock you have Evergreen Property Investments versus Messerschmitt. Now this is Pretoria High Court. The questions of law held in this case was that the adjudicator had no powers to determine the payment to a holder of a life right for a rates rebate. I know it's confusing, but if you read the case, the issue was determined not to be a financial issue which fell within the scope of Section 39(1) of the CSOS Act. Always a question of law is where the issue to be determined is an interpretation of either a policy document, a contract, or a statute. In this case, it was a policy that the community scheme had in respect of rates rebates that they were offering to life rights holders in community schemes, and whether that specific rates policy entitled a holder of a right of occupation in that community scheme to that rebate. The appeal was upheld and the adjudicator's finding was set aside. Sticking into Gauteng, towards the end of November 2018, or towards the end of 2018, Waterfall Hills versus Jordan. This one's quite a funny one because some interesting facts here. There were some frogs causing sleepless nights for a couple that lived in the community scheme for only a few months every year. They claimed that the koi pond attracting a specific species of frog should be closed up and removed because one of the couple had a sleeping disorder and she couldn't sleep with this loud croaking of a specific type of frog. And I'm digressing, but they even brought a frog expert to tell the court that this specific frog has, a croak which is above the acceptable decibel level in the area. And it was a really, really interesting case. Some people have a lot of money to argue about frog noises. Anyway, the question of law to be decided there was the adjudicator's order was actually against the association, but no relief was actually sought against the association. So the adjudicator made an order against the party that no relief was sought against. And there was no mention of procedure by the judges here, so they had no issue with what procedure the parties followed. And the conclusion arrived at was that the adjudicator had interpreted certain documents, the conduct rules, the Sectional Title Schemes Management Act, and therefore these were points of law, and the adjudicator's ruling was set aside. They had to close the frog pond. So then we move into 2019. You can go over to the next slide, please. In Manure versus Bay Dunes in Cape Town, one judge sitting, the applicant sought a declarator that Section 13(1)(g) of the STSMA applied to certain conversions of garages, that the adoption of the conduct rule at a meeting was invalid, and that some special resolutions adopted at that meeting were invalid. So you can already see the interlocking nature between questions of fact and questions of law in a situation where you have to determine if a meeting was correct or if there was a special resolution that was validly approved. So the question of law here was the meaning ascribed to the word section in Section 13(1)(g). That is a reference to the section being the part of the unit of the unit owner's section, and whether the correct procedure was followed to adopt that special resolution. Some garages were unlawfully converted to living quarters, and that was found on the facts in the adjudication. No changes to the facts allowed, only on a question of law. What was it? It was a statutory interpretation question. That was whether the meeting was correct and whether the specified resolution was passed on the facts in accordance with the Sectional Title Schemes Management Act. The adjudicator was found to have erred on a question of law in multiple areas in the way that it was calculated that there was a quorum, and in the way that it was calculated that a special resolution was validly passed. So the ruling was set aside. So in that case, you can appeal to the High Court against the CSOS adjudication order that makes a finding on whether a special resolution was obtained or not. This is the case that Gauteng practitioners and Cape Town practitioners quote the most. That's Stenison versus Linton Park. It was, I would say, the genesis of it wasn't the genesis of the interjudicial debate on procedure, but certainly the next step. This was a full bench decision, so 3 judges presiding in Joburg, and they determined that a notice of appeal must be lodged. No affidavits, and they rejected the notice of motion procedure. They said, we just want arguments on the law. And the judges did make a statement in the judgment that it is a rehearing of the merits on a question of law. That can be quite confusing, because if you say it's a rehearing on the merits, are they making determinations on fact? No, please don't get confused. The rehearing of the merits on a question of law can be confusing, but what it means is that they will not determine the facts afresh. They will hear the decided found facts and then make their own conclusions of law and decide whether or not the adjudicator specifically erred on a question of law. The point was a procedural outcome, though, as the parties had already settled prior to the ruling, so there was no need to set aside the adjudicator's ruling or uphold that ruling. It was already settled prior to the hearing of the case. The judgment, though, is not being followed in any other jurisdictions. It is only being followed in Gauteng. We are the lone wolves here. Okay, moving to Port Elizabeth High Court, Ward versus San Paulo. There, a notice of motion was presented before one judge sitting on his own, and it was alleged that the adjudicator had acted beyond their powers. Once again, an allegation that the adjudicator had no power to make the finding that they did, and that they erred on questions of fact. Well, we know that that was not going to be anything that the judge had powers to hear. They cannot hear any arguments on questions of fact. But there was no record because the applicant could not get the record from CSOS in time. So the appeal was lodged late. The court said that condemnation is possible, but there was no formal application in the case. There was a dispute. There was no formal application for condemnation, that is, in the case. There was a dispute of fact that could not be resolved on the papers, and it was a question of law only that was possible for the court to determine. So quite a mess of a case, and unfortunately, the application was dismissed. So it just goes to show how important it is to get everything in place before you go to the High Court for an appeal against an adjudication order. Still got quite a bit of time, so I'm going to move a bit slower now. The 4th of September case of Kingshaven was where the interjudicial debate between Western Cape and Gauteng continued. That is the debate on procedure, what to do, notice of motion or notice of appeal. The reality is, in Kingshaven versus Boertel, I would say the best case to read, if you don't have a lot of time, that's the best case to read to decide for yourself whether there's a question of law or a question of fact. Because the Honourable Justice Binns Ward there goes through a full discussion on how to distill questions of law from questions of fact. It is not easy, and so he continued. The discussion there was that there were conflicting decisions in the process to follow on appeal, whether it was notice of motion or notice of appeal. They did not stray from Shema Yahu, unsurprising because the same judge wrote Shema Yahu judgment. Kingshaven followed Shema Yahu. That is, a notice of motion is preferred in Cape Town, in the Western Cape, and supporting affidavits are required. The CSOS appeal there was dismissed because the adjudicator had no jurisdiction to interdict the homeowner in the way that they did. The interdict was granted prohibiting the homeowner from parking in the visitors' bays. So the adjudicator refused to issue such an order because they said that it was not within their powers. So the court order, the High Court actually does have that power, and on appeal then they issued that order to say that the homeowner is restricted from parking in the visitors' parking bay. Well, once again, a lot of money spent to stop someone parking in the visitors' parking bay. Anyway, continuing with Rapallo versus Dlamini, also in Cape Town, one judge presiding. You'll see a golden thread running through my address to you. Where it is in Gauteng, you usually get two judges. Where it is in Western Cape, you get one judge, because the notice of appeal here is heard by two judges, and a notice of motion application to on appeal in the Cape Town High Court and in Pietermaritzburg or Durban will be heard by one judge. So those are the big differences. In Rapallo versus Dlamini, the Cape Town High Court had to entertain whether or not an adjudicator ordered repayment of certain penalties charged by the body corporate validly. So the adjudicator had ordered repayment of certain penalties. There were multiple misdirections on the law, and certain facts were not even determined by the adjudicator. So this is an example where the adjudicator had made a decision, misdirected themselves on questions of law, and I'll get to that now, but also didn't make any findings of fact that would have been necessary in order to determine certain, or in order to make a conclusion of law in a certain issue. So in this case, the trustee resolution was said not to be required for fines already imposed in terms of the rules, and a special resolution was not required for conditions for building works to be imposed if the discretion of the trustees was confirmed in terms of those conduct rules. This is an unusual case because the appeal was upheld, but the matter was referred back to CSOS for determination afresh on the facts, because the court is only the High Court is constrained to determine questions of law only, but could not find in favor of either party because the adjudicator hadn't made a finding on a question of law that was crucial to that analysis. So that is also a possible outcome you could find if you go to court on an appeal against a CSOS adjudication order, and there are crucial findings of fact that you can't find in the adjudicator's ruling. So just keep that in mind as well. It might be a way for you to have the matter reheard in some cases. You can go to the next slide, please, Marina. Okay, so now we're talking about Royal Palm versus Vaslati Investments, again back in KZN. Here, one judge presided, and it was in a matter where the adjudicator had ruled that the body corporate's rules were invalid as they did not comply with the new prescribed management rules. The body corporate then appealed under a notice of motion process and appealed under the Stenison process. Lots of confusion in this case. So the parties actually launched two processes to the court: a notice of motion supported by affidavits, and then the notice of appeal process in case they were wrong. The point of law there challenged was an interpretation of a statute, so which rules applied and whether the former developer was now just an owner after he had completely developed all the land that was possible to be developed, but still remained as an owner of some of the sections. Obviously points of law, because it involves interpretations of statutes and positions, statuses of a specific unit owner. The challenges were to the power of the adjudicator to invalidate an old rule which was inconsistent with the new rules, and the appeal was upheld, notwithstanding that confusion. I think the judges felt a bit pity for the parties because of the differing views across the jurisdictions. Going to Joburg, in this case, Chelson Hall versus Mohammed, it was a leave to appeal application against an order that dismissed an appeal against an adjudicator's order. Only one judge presided here. The appeal was lodged out of time and no grounds for condonation were argued. The appeal must be lodged within 30 days of the adjudication order as stipulated in this case. No application for condonation was provided for the late appeal, and therefore no reasonable prospects of success, and it was dismissed. So it wasn't an appeal, but it's just showing you how Gauteng are treating this condonation issue. Already in Chelson Hall versus Mohammed in June 2021, they had already made some stark statements about that process. Then moving back to Cape Town, Prague versus Mitchell's Plain Industrial Enterprises. This case appears to be from the Western Cape, and it was a matter heard after Shmayayu and Stenison, but it was lodged and heard on appeal before two judges rather than on notice of appeal or notice of motion. So the parties in this case did not follow what Shmayayu and Kingshaven had said they should do. They filed a notice of appeal. In any event, fire damages in the case being argued was fire damages on a sectional title unit, which occurred as a result of some failures to comply with insurance requirements. The adjudicator was held not to have had the jurisdiction to entertain a dispute for the claim for delictual damages. So the court still heard the case, but probably also in pity for the parties in terms of confusion that may have arisen as a result of the different processes. But in this case, the adjudicator was held not to have had the power to order delictual damages. So the appeal was upheld. Then going back to Joburg, in August 2021, we have Central Park versus Paxton. One judge was presiding here. Interesting one because it was an urgent application to stay the effect and enforcement of 2 adjudication orders. Now, the adjudicator had ordered the body corporate to hold a meeting to consider certain impugned management rules. And then another adjudicator in a separate case had ordered that the contributions levied on the owners was unlawful and should be adjusted. If you go and read the first order from the adjudicator, it was completely nonsensical, as it only required a meeting with no outcome. So it had no effect. So the judge actually interdicted the enforcement of that adjudication order. It was simply unenforceable. It was vague. There was not possible for the party to perform that order, to perform in terms of that order. The second order appeared correct, but there was no prima facie right for the interim relief sought to stay the enforcement of that adjudication order. So that one was that challenge was dismissed. You'll see later on when I talk about another case shortly that urgent applications to stay the execution of the operation of a adjudication order is not very simple. I know that there's a provision in the Act that says you can, but you'll note when I get to that case, Conrad versus Key West, that you've got to be careful here, and you need to speak to a senior attorney before you decide to go that route, whether you're in Gauteng or Western Cape, and I'll tell you why shortly. Please, can you go to the next slide, Marina? I think this will be the second to last one. So, all right, we are back in Pietermaritzburg, and 3 judges presided in Derby Downs versus Assegai River Properties. This was an appeal on notice of motion to the High Court, and then an appeal against that decision of the High Court to a full bench. So that's why there's 3 judges here. It was interesting because the adjudicator's decision was overturned by the single judge. The disgruntled party then further appealed to the full bench of the High Court, and they then overturned and re-established the adjudicator's order. So don't give up. If you've got the money, don't give up on your appeal process. You may still get lucky. If a single judge or 2 judges for that matter rule against you, you still have the opportunity to appeal further. So the question here was whether ratification of a prior decision of the directors of the HOA was valid in law. And in this case, if I recall correctly, it was a decision that they had taken 20 years ago, which was being asked for, which they were attempting to ratify today. And the adjudicator was initially correct, and so the appeal to the full bench was upheld, and they overturned the single judge's ruling. Very, very interesting case indeed. Then moving to Ellis versus Palm Grove, still in Pietermaritzburg. This was where the adjudicator had found that the body corporate had suffered damages as a result of breach of fiduciary duties and ordered the unit owner to pay the body corporate some damages. The adjudicator's jurisdiction to order the relief that she granted was challenged, and because of that, it was a question of law. It was then determined she had no jurisdiction to order damages in the way that she did, and the appeal was upheld. The adjudication order was then set aside. It's not entirely clear why 3 judges heard that case. It may have also been similar to Assegai, where it was an appeal on an appeal already heard by a single judge. But if anyone knows any further details on that case and can shed some light on it, please don't hesitate to let us know. In Cliffendale Villas versus Mbawani, this is in Pretoria, 1 judge was presiding here because it was an application to stay the enforcement of the adjudication award. In this case, simply the adjudication order was stayed pending a condonation application for the reinstatement of an application for the appeal, because they did not appeal in time. The appeal had lapsed. They asked for condonation. In that time, they wanted the adjudication order to be stayed from enforcement to obviously protect the effectiveness of their appeal if the condonation application was granted, and so the court awarded it to them. Fairly simple case. But on the same day, in Pretoria High Court, Duinhoek Equestrian Estate, the first of the Duinhoek Equestrian Estate cases, there is a second I'll tell you about shortly. This case, one judge presided, and it was an application to set aside a notice of appeal and record. So the issue here was the appeal was lodged by notice of motion in Gauteng following Stenison, and they asked for urgent relief to stay the operation of the adjudication order pending the appeal. But they launched the appeal on notice of motion, and then several days later, even a month or two later, they filed a notice of appeal and record after the pleadings had closed on the notice of motion procedure, and asked for and after they had already received that urgent order staying the effect of the adjudication order. So a bit confusing, but suffice it to say, in summary, the parties lodged the notice of motion procedure in Gauteng, which was wrong. They realized this, and then several days or months later, they filed the notice of appeal and addressed certain other issues in their notice of appeal that were not addressed in their notice of motion, trying to slip in some additional arguments. And they tried to argue that Stenison wasn't binding in Pretoria, but Stenison was ruled on by 3 judges in Joburg and is binding in Pretoria. So that was reaffirmed in Duinhoek Equestrian Estate Case 1. The filing of the notice of appeal and record long after the close of pleadings was very prejudicial to the parties and was set aside. So this is a case in Pretoria where they actually forced the party to commit to the process they had initially started, notice of motion, even though it was wrong and should have been in terms of the notice of appeal process. Same case, leave to appeal was applied for, and in July 2022, leave to appeal was granted to the full bench of the Pretoria High Court on whether striking out the notice of appeal was correct. It's going to be very interesting because that court is going to have to say that notwithstanding the party used the wrong process, it should have used the notice of appeal process when it eventually did file the notice of appeal process, and that it was struck out, that decision was correct as well. Very, very interesting to see what the judge would say there, what the judges will say in the Duinhoek Equestrian Estate full bench decision. Then you'll see Conrad versus Key West Body Corporate at the bottom of the current slide, but it is the next one in the chronological order that I wanted to address you guys on this overview. So Conrad versus Key West was an urgent application to stay the operation of an adjudication order. Remember I said this is not so easy. And the issue arose here because it was in the Pretoria High Court, and the issue arose here that that was to the extent that since there was an appeal, the enforcement of the adjudication order was automatically suspended. So what do I mean then? There is a specific provision in the Superior Courts Act, Section 18.3, that says that once you've appealed, the operation of the order against which you are appealing is stayed. But there is also this separate section in the CSOS Act that allows a party to go to court on an application to stay the operation of the order. So now we're in a position where if you're in Gauteng and you want to stay the operation of an order and you file a notice of appeal, arguably it does automatically stay the operation of the adjudication order. But the uncertainty created by Conrad versus Key West is that you may not be successful in an urgent application to stay the operation of the adjudication order because, one, it may not be urgent, as was the case in Conrad versus Key West, and 2, you may have already had the benefit of staying the operation of that adjudication order by virtue of the fact that the Superior Courts Act automatically stays the operation of an order appealed against. So very confusing how the cases have evolved up to now, and I'm hoping, as I will say in conclusion, that the SCA resolves all of this. But before we get to the conclusion, very interesting case was Incala versus Park Avenue at the top of the slide. Here, 2 judges presided. It was Pretoria High Court. No leave to appeal is required in terms of Section 57. That was ruled here. It was clarified that no, you do not need leave to appeal in terms of Section 57. It is a statutory right, which occurs by operation of law. It does say in Nkala versus Park Avenue, 2 judges ruled that the appeal must be lodged within 30 days, otherwise it lapses. And no condonation for the late filing is possible. So this is where we already mentioned before, there are differing views. And I'm going to go straight to the Ocean View, Baxter versus Ocean View matter, because it's related to the same topic. There, 2 judges presided in Cape Town High Court and ruled the opposite, but did not mention Nkala, and it was never argued like it was in Nkala, because the party seeking condonation, well, it wasn't opposed. The application for condonation was not opposed, and it was a hearing on the papers, not an oral hearing. So if it wasn't contained in the heads of argument, then the court would not have dealt with it. They're in Central, still in Central Square. They're on in the Ocean View versus Baxter case. You have a situation where it was an appeal against an adjudication order, which was upheld, and the body corporate's right to levy contributions on the unit owners' exclusive use balconies also claimed the credit of the value amounts paid in excess of a lower levy contribution, which was the previous contribution. So it's quite confusing, but let me summarize it and say that the appeal was against an adjudication order which had allowed the body corporate to charge a levy on a unit owner's exclusive use balcony, and ordered the body corporate to did not order the body corporate to repay any of those amounts to the unit owner. So the unit owner appealed. And he appealed by notice of motion correctly in Cape Town. Condonation for the late filing was approved, was upheld by the court, because they said that the court does have power to condone in the absence of a statutory provision. They actually held that it was implied by the provision that condonation was possible, very opposite to what Nkala had done. And both judges provide authority from the Supreme Court of Appeal and Appellate Division to support their views. So once again, a gray area. And in that case, Baxter versus Ocean View, it was held that it was not within the objects of the Act to consider the appeal time limit to be an expiry period, because then bad decisions would be irremediable, and the court does have power to condone non-compliance. So the delay in this case for bringing the notice of appeal was the conflicting decision in Stenison. So once again, Stenison being the yardstick by which the court in Ocean View decided that condonation was necessary. And they also said it was in the interest of justice to do so. So the body corporate in this case was ordered to either levy contributions to maintain EUAs itself, or in terms of the conduct rules, amend them to ensure that the holders of the EU of the exclusive use right maintains it. If the latter is adopted, that is the conduct rule approach, then they cannot and they are not entitled to levy a contribution for that same purpose. It would be a duplication. On the merits, the adjudicator erred in failing to recognize this crucial distinction, and it was held that it wasn't for the court to determine what that levy contribution would have to be, and it was referred back to the body corporate in terms of that case. So that was 8 days ago. Very interesting case indeed. I'm almost done. I know I don't have a lot of time left. So another case which should have been mentioned at that NAMA conference but hadn't been reported yet, so I only came to know about this recently. It was the body corporate of Alessio versus Cottle, 2 judges presiding, Cape Town High Court. Here the trustees raised a special levy for the replacement of a lift payable by all the members of the body corporate, but the body corporate only had 4 members. And one of the members, the guy who opposed this special resolution, Mr. Cottle, he only owned the ground floor level, so never used the lift, and was ordered to pay by the body corporate 295,000 Rand for the repair of the lift. The owner complained to the CSOS because he thought that was unreasonable, since the lift was for the exclusive use of the other owners on the upper floors. The adjudicator agreed with the unit owner, and the body corporate then appealed. The levy contribution against the unit owner was held to be unreasonable. But in this case, the appellant pursued the appeal on a notice of appeal and not on a notice of motion process, which is required in the High Court. And so the appeal was struck from the roll. I don't know why that happened, because if you look at Ocean View versus Baxter, the court there says that it would have allowed bad decisions to be irremediable if it didn't allow condonation for late filing. But yet the same court struck this matter from the roll, didn't give any room for hearing the matter on notice of appeal, notwithstanding the confusion in the law at the moment on these processes. So, yeah, a bit unfair, I'd say there. Then last case, last two cases is Joburg High Court, Rashid versus the Niger Tamil Association. Here, CSOS tried to actually get Joburg to adopt the notice of motion procedure by joining the proceedings, but they failed. The SCA will be required to determine whether or not the appeal process in terms of CSOS should be on notice of motion or notice of appeal. So please, if you have any appeals that are going to go to the High Court or to a full bench, maybe it's time we start asking for the matter to be heard by the SCA so they can clarify all of these different jurisdictional approaches. The last point I want to mention to you is on Gernon versus the Melville. It's a pending case, so the Joburg High Court has not yet determined it. Suffice it to say that this is probably the case, that the SCA should be approached if the parties fail in Joburg High Court full bench. In this specific case, the judgment isn't out yet, and I would understand why, even though it was heard, I think, in the middle of the year. And that is because so many different aspects were challenged. The appellant challenged the validity of a trustee resolution, changing a conduct rule that was in place that restricted delivery drivers from entering the complex. The question was whether they had the right to do so. And the decision of the trustees, which was later impugned, even though it was supported by a general meeting resolution, which was upheld by the adjudicator, is being challenged on the basis that it wasn't a special resolution required to change the conduct rule. Other parts of the conduct rules were also challenged here, and they had not yet been approved by CSOS. So the appellant also asked for an order directing the body corporate to ask CSOS to take the conduct rules through its quality approval process or quality assurance process as per Circular 1 of 2018. And in this case, because the appellants knew they could not apply it for judicial review, they they reserved their rights to challenge the decision of the adjudicator under judicial review and in terms of PAJA, because they were not offered a list of adjudicators to choose from, as was promised in the practice guidelines, practice notes, practice directives of CSOS, and the adjudicator then also failed to call for additional information that, had they called for, would have been provided, and then they would have come to a different decision. So they had, so it is alleged by the appellant, the adjudicator had considered material consideration, had ignored material considerations, but had ignored, considered immaterial considerations and relied on those to make a decision. So yeah, that's it. Those are that's the full case law history. Quite a lot, quite a mouthful, but thanks very much for your time, and we look forward to your questions.
Thank you so much. Thank you, Pastor. Really, really appreciate that succinct overview. You were a star, really. And when we heard you at the NAMA conference, I said, no, we must get Pastor to come and talk about appeals and reviews, because it's quite a tricky area of the law. And funnily enough, the Gonan versus the Melville, Gonan is actually my client. And we're looking forward to seeing what goes on there, because I think you're right. I think that may be a little bit of a breakthrough we can make. Just as a matter of interest, and I know we've gone over time, I'm sorry for everybody, but what is your view on notice of appeal versus notice of motion? Where would you find favorable kind of outcomes? Or you muted, just unmute yourself. Thanks. You can't unmute. Okay. All right, Fasto, sorry, we might have to come back to you on that. Sorry, I'm not sure why I can't unmute. Anyway, all right. So What I wanted to
I'm back.
say, whilst, oh, there you're back. Great. Sorry, carry
Sorry.
on.
When I unmute, the administrator just automatically disallows me from muting. But your
Okay.
question was, what would I prefer, notice of appeal or notice of review? Would I approve? Yeah, I think the notice of motion process makes a lot more sense because it would reduce the costs required for a party to challenge on a judicial review basis some of the aspects of their case that they would like to do so if they wanted to. Whereas the notice of appeal restricts you, you would only be allowed to appeal and then file a separate application for judicial review. But I think that both processes have pros and cons, and it's going to be, I don't envy the SCA judges. They're going to have a tough time to determine what the process is. I just think that what could probably curtail all of these discussions and this debate is that internal appeal process that you mentioned earlier that CSOS are trying to implement. If we can get some of these bad decisions ruled out prior to going to court, it will be a massive help to some of the members of the public and community schemes who are spending a lot of money on these appeals and review processes, where the whole purpose of this statute was to reduce those costs. So, Marina, it's difficult. Yeah.
I know, but I think that what you've said is 100% spot on. For me, it's counterintuitive. When I saw the legislation today, you take it to the High Court on appeal. I mean, it's wasting everybody's time and money. And just for the people out there to go to court on appeal, I mean, I don't know, Fausto, I mean, we're looking at hundreds of thousands of rands. It's not 20,000 rand and not 30,000 rand. It can be over 400,000 or 500,000 rand. So for a body corporate, if I lived in a complex and my body corporate said, okay, we're taking this matter on appeal, I would actually place restrictions in the restrictions and directions to say you need to revert back to the body corporate if you're going to take something on appeal, because they can land up bankrupting the complex.
Yeah, absolutely, Marina. I think you're spot on there as well. So Gauteng probably aren't going to change their tune. Western Cape definitely aren't going to change their tune, and that's why I think maybe Gernon, if he's unsuccessful, hopefully he isn't. I think he will be successful, but if he isn't, maybe that's the SCA's opportunity.
Yeah, 100%. Fausto, thank you so much again. We really appreciate you here at Women in Sectional Title. To all the ladies out there and the men who support the ladies out there, please be mindful of the next 16